First of all, I want to thank all speakers that intervened today, and I would like to also thank very much Margherita Colangelo for having organized this conference. I did very little except that the spark of the idea came from our course in European Union transport law when we were discussing something that concerns the past, that is passenger reservation systems and the platforms and that existed at that time, and the intervention by the European Commission in regulating platforms. And then we said, but these have disappeared, these reservation systems have substantially disappeared with travel agencies, but they have been substituted by Booking, Expedia, Last Minute, eDreams, and so on. So that from that, we tried to understand what had changed in the last 20 years and what the new, these new online platforms came. Now, I will not go back to the main topics which were discussed today, because I think we've heard quite enough, and I surely don't think I could add much more. I would just like to touch two topics that go towards two perspectives that are emerged today and were not in depth analyzed. Dr. Kalfas at the end analyzed the issue, but most of the speakers skirted away from it, saying we will not talk about big data. Now, there is a considerable debate, especially in the in antitrust and competition circles, on the role of big data, of data in the if it constitutes or not a barrier to entry and so on. Now, I've been trying to tackle, having worked for, well, let's say 3 decades on data, starting from personal data and then going on to other forms of data. I was trying to understand whether this issue of big data is actually data are barrier to entry, and I've come up to a rather maybe not very conventional, but all my positions are not very conventional, so there's no surprise for those who know me. The view that maybe maybe the question is badly put, in the sense that first of all we should understand what are we talking about when we talk about big data. And I have the vague impression that there is, I don't say there's not a clear idea what big data is, but obviously when we are talking to people who are involved in the technology sector, that means big data means something. For lawyers, it means something different. For those who work online, it means something different again. So I think, first of all, that the notion of big data is rather fuzzy and therefore needs better clarification. As a lawyer, I would like to first understand what do we mean what are big data from an economic point of view? And I think this is the first clarification. I would look at it from the point of view of a firm. A firm has data. This data, does it go on its accounts? Is it valued? Is it, when we do the balance sheet, the yearly balance sheet of the firm, do we put these data on the balance sheet? Do we give them a certain amount of value? Obviously, if we are selling data, we do this, but if we do not sell data, and many companies use the data for themselves, they do not put them on, they're not on the balance sheet. So I think this is a preliminary issue which I think deserves more attention. Obviously, lawyers come last, but I think this is economists, and mostly those who study the firm should understand what is the role of the economic value value of data in a modern firm, and then we can move over to competition issues, and if this is or is not a barrier to entry. Otherwise, I think we are sort of, to use a sort of a metaphor that I always use, you try to regulate property looking at theft. No, obviously there are people who steal, but we're not going to regulate property and understand what property is looking at the provisions in the penal code which sanction theft. I would like to understand better what are data in the firm and the value and how data is created and so on. Second element, it seems to me, but maybe this is biased position, that really when we talk about data, big data, and anyhow all these collection of data, we are talking really about not so much of data markets but of knowledge markets. Data are relevant because they provide knowledge. So I mean, and they are a component of the knowledge. Now knowledge is a whole lot of elements. It is know-how, it is trade secret, it is a whole lot of elements, and I think it is research and development and so on. So I have the impression that maybe that if we put big data within knowledge, the creation of knowledge, then we have a much simplified, much more simple way, because generally speaking we protect knowledge. We protect knowledge through patent, we protect through trade secret, and I would like to point out that there is somehow some schizophrenia by the European Commission being so concerned about big data used as, not the Commission, but in certain areas there is concern about data being a barrier to entry, while we have a very strong protection of data banks in Europe, which does not exist in the US. We, at a certain point in 1997, we started protecting data banks, and this distinguishes us from the US. And so it is, how can we say that data banks are protected? The way we collect, in the, let's set aside the inventive data banks, but just think of the sui generis protection of data banks. And I mean, this is somehow we are trying to give an incentive to the creation of data banks, and then we say that no, but these are data banks. The creation of this is somehow an exclusive right to extract utility from use and advantage from data banks, and then we start saying, no, but this is a barrier to entry. Just to point out that I think we need a bigger frame and not just focus on rather catch labels such as big data. And this brings me to this point, just to point out that there was a slide this morning that pointed out that maybe we're not talking about, we don't need regulation, or maybe soft regulation. Maybe we need what Cass Sunstein always talks of, of gentle nudge. And here, gentle nudge in regulation maybe is not so much on the fact that you have to force private enterprises to provide the data they have, but we have, and this is a very great role of making public data, that is data that is possessed by public entities, mainly the state and public authorities, making it not only available, but making it available on the spot. We don't need it for statistical reasons. We're not interested in having, economic data for, well, yes, it can be useful for, but for day-to-day business, we need instant information on the traffic, on what is the situation of the traffic, instant information which can be used immediately in certain areas. So I think this is the first area which maybe, I don't say needs regulated, but because the state does not need regulation. It's just simply the state, first of all, should provide more information. This information is surely invaluable to the market and create new businesses and favor existing businesses. The other issue, which brings more to regulatory issues, is to what extent entities which are mostly providing public service can be and at what conditions they should be obliged to provide data. Just let's take a typical case. Utilities, electricity utilities, water utilities, an airport, those subjects which are in a monopolistic or nearly monopolistic position and that hold invaluable information, which is not information which is relevant to competitors, because obviously it is not so important for competitors because they don't really have competitors, but it is for downstream markets which can take enormous amount advantage from this information. I think this is, when we talk about data markets, I think, and we want to talk about regulation of data markets, maybe this is an aspect that should be considered before, obviously, let's open the market and then we'll see if at a certain point there are barriers and competitive issues. I think that the data markets are still too closed from the public side, and if we open it completely up and we make it data more available, then we can discuss this. Second issue, which came up today in several occasions, is the fact that a certain amount of global intermediaries are faced with a very multiple or litigation or in somehow discussions in front of competition authorities. Now, this obviously has to do with national sovereignty and the role of competition authorities, whether in the member states of the European Union rather than Korea or India or other places or Japan. But it should be considered that these global platforms, obviously Google is a global platform, but if we look also at booking, I mean the airline and hotel accommodations, they are significantly global. I think that this issue of having common rules is essential to make these platforms more efficient, less costly, take more advantage of network effects, and obviously, as it was said this morning, reducing administrative cost of both from the authorities and from the litigation point of view, reducing that kind of cost. Now, what does this mean? This means something that has scarcely been considered lately, because, and I totally agree with that side of the coin. We have very much insisted on Internet Bill of Rights and seen the Internet as an area where there must be a certain amount of rights, and that's quite obvious. But that is only one side of the coin. I think one has to imagine also on what are the duties that are that exist on a global network. And so I think that it is time to start and think that really the Internet is not, as some very, libertarian views had it, that a place with no law and where there's no regulation, there's only self-regulations, there's netiquette and so on. I have the impression that the more we go ahead, we realize that the Internet is something very similar to what in 2,000 years ago, some time ago, the sea. The sea is a way of communications. The sea has never been a border, a barrier. The sea has been a way of communication. And we have found rules and of transnational, international communications, and we have found the law of the sea, and we have found rules that everybody abides by on the sea, and we have found them on air, we have found them on space. And I have the impression that if we do not slowly, obviously, takes time. But if we do not move in the direction of thinking that the Internet is something similar, although technologically evolved as the sea, the air, and the space, I think that we will be confronted with the fragmentation of regulations and each country doing its own rules, which I don't think is useful at the end of the day. It's very useful for global online platforms, which surely do need some rules, must respect a certain amount of rules, but at the same time their efficiency and the quality of the services that they are able to offer depends on the fact that they can have a standard service which is global service throughout most of the world, not all of the world, but most of the world. So I think this perspective, I mean the fact that a certain amount of cases, of competition cases have been brought in front of many authorities, and each of them, not each of them, many of them are not taking the same position as we have seen in Europe. I think this suggests that maybe we should do an effort, at least I speak as a lawyer whose aim is that of, creating rules, interpreting rules, applying rules, to think of a global system of rules for the internet on which players can rely on, and they know that whatever country they are, they can rely on those certain rules. So I think this of international cooperation is a very important issue for the future of networks, electronic networks, and obviously on online intermediaries. Having said this, again, thank you for being here, for having stayed here with us, and we hope I don't want to sort of pressure too much our distinguished guests, but I think that if they could transform, those who had slides, their presentation in a text as Roma Tre e-press. We have a rather efficient e-press system that can do quite quickly put together the proceedings, today's proceedings, and make them widely disseminate them and make them available to the general public. Thank you very much.